The billing alert appeared at 11:47 p.m. on a Tuesday, flagging document production charges I never authorized. I stared at my laptop screen in the dim light of my Jacksonville office. Tobias Stonegate, 42 years old, client services attorney at our mid-sized litigation firm. 15 years of practice had taught me to trust my instincts about irregularities. The alert showed 300 billable hours for document review on the Henderson construction case. Problem was, I'd handled that file personally. Every brief, every motion, every discovery response. I pulled up the case management system. The timestamps showed document production activity during my vacation last month. Someone had accessed my client files while I was in Colorado with my family. My fingers moved across the keyboard, drilling deeper into the billing records. The charges traced back to premium document formatting services. Services I'd never requested. The invoices bore my electronic signature, but the formatting looked wrong. Too clean, too perfect. I opened the Henderson file folder on my desktop. The contracts were there, but something felt off about the headers. The font spacing seemed different. The margins weren't quite right. These documents had been through our standard template system, but the metadata showed creation dates that didn't match my memory. A chill ran down my spine as I cross-referenced the billing entries with my calendar. Every single charge occurred during times I was either in court or out of the office. Someone with access to my login credentials had been systematically working on my cases. I pulled up the firm's access logs. My username showed activity at 2:15 a.m. last Thursday. I'd been home asleep. The IP address traced to our office network, but the workstation ID belonged to the conference room computer. The Henderson case involved a $12 million construction dispute. Our client trusted us with sensitive financial documents and proprietary building specifications. If someone had compromised those files, the liability exposure could destroy our practice. I scrolled through more billing entries, my stomach tightening with each discovery. The pattern extended back 6 months, always during my absences. Always on high-value cases. Always using my authorization codes. My phone buzzed with a text from Mitchell Hawthorne, the associate who joined our team 8 months ago. Working late on the Morrison deposition prep. Need your Henderson contract templates for reference formatting. I stared at the message. The Morrison case had nothing to do with Henderson. Different practice area, different client, different legal issues entirely. Unless someone needed my document headers for something else. The Henderson case had started 8 months ago, right when Mitchell Hawthorne joined our litigation team. Fresh from law school, eager to prove himself, and surprisingly skilled with our case management software. I'd been impressed by how quickly he'd adapted to our systems. We worked together on a massive FOIA response under deadline. 3,000 pages of government documents needed review and redaction within 72 hours. Mitchell volunteered for weekend shifts, staying late while I handled court appearances. His dedication seemed genuine. I'd given him access to my document templates to maintain consistency across our filings, standard practice for associates working on my cases. The firm's partnership had always operated on trust. We shared resources, login credentials, and case materials freely. But trust, I was learning, could be weaponized. I pulled up Mitchell's personnel file. His law school transcripts showed strong grades in technology law and intellectual property. His references praised his attention to detail and computer skills. Nothing suggested the methodical deception I was uncovering. The billing anomalies painted a different picture. Every fraudulent charge coincided with Mitchell's late-night access to the conference room computer. The timestamps matched perfectly. While I was home or in court, he was using my credentials to access premium formatting services. I opened the Henderson contracts again, this time examining the metadata more carefully. The original creation dates showed my authorship, but the modification history revealed multiple edits. Each edit occurred during my documented absences. Each edit used my login credentials from the conference room workstation. The pattern was sophisticated. Mitchell had been copying my document headers and pasting them into new contracts. The formatting services helped to match fonts, spacing, and margins perfectly. To casual observers, the documents appeared authentic. Only deep metadata analysis revealed the deception. I cross-referenced the billing charges with our client files. Henderson Construction wasn't the only victim. The Morrison case showed similar irregularities. So did the Blackstone merger and the Riverside Development Project. 4 major cases, all involving sensitive financial information. My phone rang. Mitchell's name appeared on the caller ID. Tobias, I'm still working on that Morrison prep. Could you email me your Henderson templates? The formatting needs to match exactly. Why do you need Henderson templates for Morrison work? A pause. Just for consistency. You know how particular clients get about document appearance. I knew exactly how particular they got, especially when someone was creating fraudulent contracts using stolen headers. I'll send them over, I lied. Instead, I called our IT administrator. Within minutes, I had Mitchell's complete access history. The data confirmed my suspicions. He'd been systematically accessing my files, downloading templates, and using premium services to create perfect forgeries. The scope was staggering. 12 cases over 6 months. Hundreds of documents. Thousands of dollars in unauthorized charges. But the real damage went beyond billing fraud. I opened the Henderson file one more time, focusing on the construction specifications. These weren't just contract headers Mitchell had stolen. He'd accessed proprietary building plans, financial projections, and trade secrets, information worth millions to our clients' competitors. My desk phone buzzed. The caller ID showed Henderson Construction's main number. Mr. Stonegate, this is Samantha Blackwood from Henderson's legal department. We need to discuss some irregularities in our contract documentation. Can you come in tomorrow morning? My blood ran cold. What kind of irregularities? We've received copies of our contracts from an outside source, someone claiming to represent a competing firm. The documents appear authentic, but we never authorized their release. The room felt smaller suddenly. Mitchell hadn't just been stealing headers for formatting consistency. He'd been selling our clients confidential information to their competitors. I'll be there at 9, I managed. After hanging up, I sat in the growing darkness of my office. The building had emptied hours ago, but I could see light under the conference room door. Mitchell was still here, still working, still using my credentials to access files he had no business touching. I gathered the evidence I'd collected. Billing records, access logs, metadata reports, and client communications. The pattern was undeniable. Mitchell Hawthorne had been systematically betraying our clients' trust for 6 months. But confronting him directly would be premature. I needed more evidence, and I needed to understand the full scope of his operation. How many clients were affected? How much information had been compromised? Who was buying our stolen documents? I locked my office and headed for the parking garage. Tomorrow's meeting with Henderson Construction would reveal the true extent of the damage. But tonight, I had calls to make and evidence to secure. The elevator descended slowly, giving me time to process what I'd discovered. An associate I'd trusted and mentored had been using my identity to commit corporate espionage. The betrayal felt personal, but the legal implications were far more serious. As I reached my car, my phone buzzed with another text from Mitchell. Thanks for the template help. Working late again tonight. This Morrison case is more complex than expected. I knew exactly how complex it was about to become. The Henderson Construction meeting confirmed my worst fears. Their legal department had received detailed copies of our contract negotiations, including confidential pricing strategies and settlement positions. The documents bore my digital signature and our firm's official letterhead. We trusted your firm with sensitive information, their general counsel said, sliding the leaked documents across the conference table. Now our competitors know our expansion plans for the next 18 months. I examined the papers carefully. Mitchell had used my document templates perfectly, copying not just headers but entire formatting structures. The metadata showed creation dates spanning the past 6 months, always during evening hours when I wasn't in the office. We're considering terminating our retainer agreement, Henderson's CEO added. This breach has cost us 3 potential acquisitions. I spent 2 hours documenting their concerns and promising a full investigation. By noon, I was back at the firm, heading directly to managing partner Samantha Blackwood's office. "We have a serious problem," I began, spreading the evidence across her desk. "Mitchell Hawthorne has been stealing client information and selling it to competitors." Samantha examined the billing records and access logs. Her expression darkened as she reviewed the metadata reports showing document creation times that coincided with Mitchell's after-hours access. "How long has this been happening?" 6 months minimum, possibly longer. I showed her the pattern of unauthorized access to my case files. "He's been using my credentials to download confidential documents, then reformatting them with his own headers before distribution." "Do we know who's buying this information?" Henderson mentioned receiving documents from someone claiming to represent a competing firm. "I suspect Mitchell has established relationships with multiple buyers." Samantha reached for her phone. "I'm calling an emergency partners meeting. We need to involve our malpractice carrier immediately." The partners meeting convened at 3 o'clock. 7 senior attorneys gathered in the main conference room, their faces grim as I presented the evidence. The financial implications were staggering. Henderson Construction alone represented a $2 million annual retainer. "We need to contact the statewide legal discipline authority," partner Samantha Thornfield said. "This isn't just theft. It's professional misconduct that could destroy our reputation." "What about criminal charges?" asked another partner. "That depends on the scope of the operation," I replied. "If Mitchell sold information to multiple buyers, we're looking at commercial espionage charges." Managing partner Blackwood assigned me to lead the internal investigation while she contacted our malpractice insurance carrier. "Document everything," she instructed. "We need a complete audit of every case Mitchell accessed." I spent the next 3 days reconstructing Mitchell's activities. The case management system logs revealed a sophisticated operation. He'd accessed 47 different client files, always during evening hours, always using my credentials. The stolen information included merger negotiations, settlement strategies, and confidential financial data. On Thursday morning, Bar Compliance Officer Thomas Wilson arrived to begin the formal investigation. Wilson was a methodical investigator with 20 years of experience handling attorney misconduct cases. "Show me the access logs," he said, settling into the conference room with his laptop and recording equipment. I walked him through the evidence chronologically. Mitchell's pattern was consistent. Access my files after hours, download confidential documents, reformat them using my templates, then distribute them to unknown recipients. "Have you confronted the subject attorney?" Wilson asked. "Not yet. We wanted to complete the evidence collection first." "Good. We'll handle the confrontation formally. I need copies of all billing records, access logs, and client communications." Wilson spent 2 days interviewing staff and reviewing our security protocols. His investigation confirmed what I'd suspected. Mitchell had been operating a systematic information selling scheme for at least 8 months. On Friday afternoon, Wilson requested Mitchell's presence in the conference room. I watched from the adjacent office as Mitchell entered, still unaware of the investigation. "Mr. Hawthorne," Wilson began, "we're investigating irregularities in document access and client confidentiality. I need to ask you some questions." Mitchell's confident demeanor shifted immediately. "What kind of irregularities?" Wilson placed the access logs on the table. "These records show you accessing senior attorney files using unauthorized credentials. Can you explain these activities?" The color drained from Mitchell's face. "I was working on collaborative cases. Tobias gave me permission to access his files." "At 11 p.m. on weeknights? For files unrelated to your assigned cases?" Mitchell's story began unraveling quickly. Wilson presented the billing discrepancies, the metadata evidence, and client complaints about leaked information. Each piece of evidence made Mitchell's position more untenable. "We have documentation showing you reformatted confidential documents using stolen templates," Wilson continued. "Multiple clients have reported receiving their own confidential information from external sources." Mitchell finally broke. "I needed the money. Law school loans, credit cards. The information was just sitting there in the system." "How much money did you receive?" $30,000 over 8 months. Different firms paid different amounts depending on the information value. Wilson documented Mitchell's confession carefully. The scope of the betrayal was even worse than I'd suspected. Mitchell had sold information to 5 different competing firms, compromising dozens of our clients' confidential strategies. The formal disciplinary hearing occurred 3 weeks later. Wilson presented the evidence to a 3-member panel of the statewide Legal Discipline Authority. Mitchell's law license was suspended pending criminal investigation. Our firm faced immediate consequences. Henderson Construction terminated their retainer, as did 3 other major clients. The malpractice insurance claim exceeded $500,000 in potential damages. But we also received unexpected support. Several clients appreciated our thorough investigation and transparent communication about the breach. 2 new clients specifically hired us because of our ethical response to the crisis. Mitchell faced criminal charges for commercial espionage and computer fraud. The district attorney's office built their case using our internal investigation as the foundation. His guilty plea resulted in 18 months in prison and full restitution to affected clients. I testified at his sentencing hearing, describing the systematic nature of his betrayal and its impact on our clients' trust. The judge noted that Mitchell's actions had damaged not just individual clients, but the legal profession's reputation. Your betrayal of professional trust warrants significant consequences, the judge told Mitchell. You violated the fundamental principles that govern attorney conduct. The firm implemented new security protocols based on Wilson's recommendations. Multi-factor authentication, regular access audits, and restricted after-hours system access became standard practice. 6 months after the investigation concluded, I received a call from the Jacksonville Bar Association. They wanted me to speak at their annual ethics seminar about identifying and preventing attorney misconduct. Your firm's response to this crisis demonstrates how proper investigation and transparency can actually strengthen client relationships, the program coordinator explained. I agreed to speak, knowing that sharing our experience might help other firms avoid similar betrayals. 12 months later, I stood in my new corner office overlooking the St. Johns River. The nameplate on my door read, Tobias Stonegate, Senior Partner at Riverside Legal Group, a boutique litigation firm I'd co-founded with 2 former colleagues. Our practice focused exclusively on commercial litigation and professional liability defense. Word of our ethical handling of the Mitchell situation had spread throughout Jacksonville's legal community. Clients sought us out specifically because they trusted our commitment to transparency and accountability. The morning sun reflected off the river as I reviewed our first-year financial statements. Revenue exceeded projections by 30%. We'd hired 4 associates and 2 paralegals. Our client retention rate was 97%. My phone buzzed with a text from Samantha Hawthorne. She'd joined our firm as Director of Client Relations after leaving the old partnership. University of Florida Law Review wants to publish your article on digital security and law firms. Congratulations. I smiled, remembering the countless hours spent documenting our investigation and its lessons. The article detailed specific protocols for preventing document theft and monitoring system access. 3 law schools had already incorporated it into their professional responsibility curricula. A knock interrupted my thoughts. Thomas Wilson, the bar compliance officer, entered carrying a thick folder. Final report on the Mitchell case, he said, setting the folder on my desk. Thought you'd want to see the complete disciplinary record. I opened the folder. Mitchell's disbarment was permanent. His criminal conviction included a lifetime ban from practicing law in Florida. The restitution payments to affected clients totaled $800,000. Your firm's cooperation made this investigation possible, Wilson continued. We're using your case as a model for training other compliance officers. After Wilson left, I opened my laptop and accessed the law school portal. The University of Florida had invited me to guest lecture on attorney ethics next semester. I'd also been asked to contribute to a comprehensive study on partnership betrayals in mid-sized firms. The afternoon brought a call from Henderson Construction. They wanted to discuss returning as clients. Their new general counsel had reviewed our handling of the Mitchell situation and was impressed by our systematic approach to crisis management. We made a mistake leaving your firm, he admitted. Your transparency during that difficult period showed real character. I scheduled a meeting for the following week, knowing that rebuilding trust required patience and consistent ethical behavior. As evening approached, I reviewed the final chapter I'd written for a law school textbook on attorney misconduct. I co-authored a law school textbook chapter on attorney misconduct with Professor Williams from Florida Coastal. The chapter focused on early detection methods and proper response protocols when discovering colleague betrayals. The textbook would be published next spring, ensuring that future attorneys learned from our experience. Prevention remained better than prosecution. My phone displayed a news alert about Mitchell's release from federal prison. He'd served 16 months of his sentence. The article mentioned his permanent disbarment and ongoing civil litigation from former clients. I closed the alert without reading further. Mitchell's story had ended the day he chose betrayal over integrity. My story continued with each ethical decision, each transparent client communication, each day spent rebuilding trust in the legal profession. The river outside my window reflected the setting sun, painting the water gold and crimson. Tomorrow would bring new cases, new challenges, new opportunities to demonstrate that legal practice could be both profitable and principled. I gathered my files and prepared to leave the office. The security system's green light confirmed all access logs were properly recorded. Every document was encrypted and backed up. Every client communication was documented and secure. The lessons from Mitchell's betrayal had become daily practices, woven into the fabric of how we conducted business. Trust, once broken, required constant vigilance to rebuild and maintain. I locked my office door and walked toward the elevator, knowing that justice had been served and professional integrity restored. The legal community was stronger because we'd chosen transparency over cover-up, accountability over denial. It was finally over, and the silence felt earned.